It being a little after 1 o'clock, we'll call the hearing on House Bill 1153 to order, and come on up. Welcome.
Thank you, Mr. Chair. Good morning, and thank you. For the record, my name is Peter Torosian. I represent Rockingham County District 14, which is the towns of Atkinson and Plastow. I'm here before you as the prime sponsor of House Bill 1153, which is relative to absentee ballot requests. This is a fairly simple bill, and what it aims to do is to clarify that absentee ballots may not be mailed to an absentee voter before an absentee ballot application has been received and approved. Now, the current RSA does address this somewhat. However, we did hear testimony before the House Election Law Committee from a town clerk that in actuality, official absentee ballots had been mailed out to people who had not been verified as being actually registered to vote in the state of New Hampshire. And what this bill does is to clarify and to strengthen the law to ensure strict compliance with RSA 657:12 to ensure that that's verified, that you have the legal right to vote in New Hampshire before you get an official absentee ballot. And that's quite simply what the bill does. It aims to strengthen election law. It's no secret in the last couple of years, there's been a lot of concern amongst our citizens and voters that as to whether or not we have really good safeguards in place to ensure that everybody's legal right to vote is counted, and that we don't have any kind of interference from people that may not have the right to vote. So, there's an old saying that that possession is 9/10 of the law, and I kind of look at that the same way with an absentee ballot, an official absentee ballot. You shouldn't have one if you don't have the right to vote. So that's it. That's really what it does, quite simply. And with that, I'll conclude my testimony and take any questions that members of the committee may have.
Questions from committee members? Senator.
So I just want to understand, right now the law provides that the applicant only receives their absentee ballot if they're on the checklist. So if they're on the checklist, they do have a right to vote. I'm not understanding why this language is needed if that's already in the law.
Right, and that came up in the House, and because we had testimony that some town clerks are already doing, or had under oath, well, it wasn't under oath, but during testimony, they indicated that they were sending out to potential voters in town that had not been verified as being on the checklist and or being registered to vote. So this clarifies and strengthens the RSA, is what this language does.
Follow up?
No.
Seeing no other questions, thank you very much. Paul Bergeron, representative from the great city of Nashua.
Thank you, Senator, members of the committee. I'm here today opposed to House Bill 1153, and I think I'll start by answering the question Senator Susi just posed. Back in 2005 or 2006, during the HAVA planning sessions, questions were raised about how we could expedite the voter registration process along with the absentee ballot request process for voters who were out of town and couldn't come into the office to register to vote close to Election Day. And I believe the suggestion was made to change the law to allow city and town clerks to send the absentee voter registration materials and the absentee ballot request form and the absentee ballot to the voter, so all those materials could be returned to the city clerks in time for Election Day. In other words, it might take 30 days to get them registered to vote, then another 30 days to get the absentee ballot back to the office so that the vote could be cast. And what happens at the polling place on election day, and there aren't a lot. I know in Nashua during the presidential election, there might have been 5 or 6 in each of the 9 wards. The first thing the moderator has to do is open the envelope, take out the voter registration materials, bring those over to the checklist supervisor. They will make a determine if the person has met the qualifications to be registered as an election day registrant. If so, the moderator is notified of that fact and the absentee ballot can be opened and processed. If they're not on the checklist, they're not qualified to be on the checklist, the supervisors will notify the moderator of that fact and the absentee ballot will never be opened. So that process was put into place about 16 years ago. It's not used a lot, but it really is used. And I think we all know the problems we have with mail today. I got a nice Christmas card from one of my cousins. He mailed it on December 22nd this year. I got it on January 24th. So there is a concern about the flow of mail back and forth between potential voters and the actual absentee voters. I also concur with Senator Soucy's opinion that the new words on lines 9 to 11 really are redundant. They say the same thing that lines 5 and 6 say. A town or city clerk shall forthwith ascertain if the applicant is on the checklist of the town or city. If the applicant is on the checklist, the clerk shall send the materials provided for. So I think the new language is redundant. We do have perhaps a problem that there are conflicting statutes here in terms of providing the materials to someone who wants to register to vote absentee and apply for their absentee ballot at the same time, as well as the statute. But I don't think this bill is going to clarify anything. I think if that is something that the senators want to address, it needs different legislation to do that. And I'll answer any questions if there are any.
Questions from committee members? Seeing none, thank you very much.
Thank you.
That is the last person that I have signed up. Is there anyone else out there that wants to speak on this House bill? Apparently, we have another sheet. Okay, so we have 2 people not speaking, 1 opposed, and 1 in favor. So with that, we'll close the public hearing, and if the senators agree, we will go into executive session and try to do a couple of bills.
Second.
Okay. All those in favor say aye. Okay, we are in executive session. Not trying to take the bills in any particular order. The 1010, I think, is one of the bills that I thought could be exec today. We'll see what you guys think. We have a motion of ought to pass on House Bill 1010. Do I have a second? Do we have any discussion?
I think it's the member stated this is more of an omission when we originally passed the bill that we didn't include municipal data, so.
Yep.
Makes sense to add that language.
Ought to pass. Seeing no other discussion, all those in favor of ought to pass, say aye. Aye. Opposed? Seeing no one opposed, do I have a motion for consent?
Second.
Okay. All those in favor of consent, say aye. Aye. Opposed? Anybody particularly want to take that one out? Hey, Senator Birdsall. 1122. We have a motion of ITL on 1122.
I'll second that.
We have the second. This bill, my notes, says there was quite a bit of testimony that talked about that it wasn't needed, they can do it. Talking about liability, and therefore I would support the ITL motion. Anyone else want to have a discussion on this bill?
Not a discussion, but I'll just add the comment that I think this is an existing power of municipalities, and so I don't want to create ambiguity.
Say that again?
She said that they can already do it.
Okay.
Thank you.
No problem.
You're so soft-spoken.
I know, but you know,
No, not you, her.
I wasn't thinking you were talking about me. But I have a wife that is soft-spoken sometimes, and you know, I try to pay attention.
Okay.
All right. Is there any other discussion? All right. We have a motion of ITL. All those in favor of ITL say aye.
Aye.
Opposed? Do we have consent?
Second.
Okay. All those in favor of consent say aye.
Aye.
Opposed? And is there anybody particularly wants to
I'll
take
take it
it?
up.
Ruth. Okay. And if I have a motion come out of executive session, we can start our next hearing. All those in favor of coming out of executive session, say aye.
Aye.
All right. Our next bill. Here's the sheets. You can just blame me when you don't have one. Back again, huh? All right. 1157.
Thanks again. I'm still Peter Terosian, representing Rockingham 14, Atkinson, and Plastow.
Welcome, Representative.
Thanks again, Mr. Chair and members of the committee. So I'm here again as a prime sponsor of House Bill 1157 relative to electronic ballot counting devices. What this bill attempts to do, and I believe would do, is to ensure that any current vote counting machine or any new ones purchased by the cities and towns in New Hampshire would never be connected to the internet. Full stop on that. So we've heard a lot of testimony. As a member of the House Election Law Committee, I've gotten many emails in regard to, again, voter integrity and the concern that, you know, whether it's true or not true. I think most of us in this room have probably been hacked at one point or another with our emails and other various activity we may have online. And so 1157 would require that, again, the towns and cities just don't connect these things to the internet. So that would prevent any kind of problems with some kind of accidental or somebody for fun or intentionally trying to hack into those machines and potentially cause a problem with how the machine operates and raise some havoc that may not change the ability of that software in the machine to count the votes correctly. This bill did pass out of committee 20-0, and it was on the consent calendar of the House and passed through the House on consent. So I hope that you consider passing this legislation. This should help as well to help mitigate some of the growing mistrust people have in regard to what happened down in Wyndham, where that wasn't, directly influenced by being connected to the internet, but that left a lot of people concerned and doubtful as to the integrity of elections. So this is a small step towards bringing back confidence and integrity to the voters in the state. And this bill, and I failed to mention the last one I testified on, both were supported by both the current Secretary of State and his predecessor. So again, it's a simple, common sense legislation, and to ensure that nobody can log into the system, period. It amends RSA 656:42, and says that no electronic ballot counting devices shall have access to be connected to the internet. And why I think this is a good time to bring this, a lot of towns are on the verge of buying new vote counting machines as their old ones are becoming obsolete, and the new ones have much more capability in regard to being connected. So that's really what it does in a nutshell. Again, this will bring more trust and confidence back into our elections. And with that, I'll conclude my testimony and answer any questions that the committee may have.
Thank you. Are there any questions from committee members? Senator Virgil.
Thank you, Mr. Chair. Thank you for taking my question. So I know that most of our machines are starting to get really old, and they're not typically connected to the internet unless they're doing an upgrade to the memory motherboard or whatever they call it. Wouldn't this limit the number of new machines that would be able to purchase? Because my understanding is the majority of them do connect to the internet.
Thank you for the question, Senator. No, it won't, because those machines, I looked into it, can be made so that they're not, the machine has the capability. Some of the old machines have that capability, and they're somewhat blocked. But this would require that those machines not have the physical connection. So the new machine may have the capability in the machine, but the actual outlet would be disabled for the use of connecting to internet.
Follow?
Yes, ma'am.
Just, when you say connecting to the internet, are you meaning just during the voting process, or before or after, or at all?
Well, the legislation is clear that at all, because talking to people, including the Secretary of State's office, I asked that question: would this in any way slow down the vote counting or impede in any way getting the process done in an efficient manner? The answer was no. We don't currently connect them, and this is to ensure that we don't connect them in the future as new machines come online. It's that simple. Thanks again for the question.
Senator Burton, welcome.
Thank you. And I guess my question is, did you guys consider in a future state, or did it come up in the House, whether future devices may want to be connected to the internet with appropriate, protections in place in the software? And I ask because, as you said, things are always changing, and I understand we don't need connection to the internet now. I just didn't know if that issue had been dealt with at all.
So thank you for the question, Senator. It didn't really come up, but I would answer it this way. I don't think either this body or the other body of which I sit on is going away anytime too soon. So if we pass this legislation and it's determined somewhere in the future that we may want to change it, it certainly can be amended. But again, the mindset was there's really no good reason to do it. I mean, I can't predict 10, 15 years down the road what we may or may not be doing. And this is one to help restore confidence, because there's no secret that many people have grown wary and concerned about problems with getting hacked. And as I said earlier in my testimony, I've been hacked before. I know other people that have. And it seems like, to me, a common sense approach to ensuring we don't get hacked, period. I'm not saying it's nefarious or not. It's just ensure it doesn't happen, period. I mean, I remember when Social Security rolled out all this online information, And right away, there were problems with it, and they very quickly pulled it back down. So it's one small step to ensure that voter integrity stays high in the state of New Hampshire. Thanks.
Thank you.
Additional questions? Seeing none, thank you very much for your testimony. Grant, would you check and see if there's additional people on the list? I only have one other person that's not speaking who is in support. Okay. Secretary of State, did you want to comment on House Bill 1157 or?
Mr. Chairman, to the extent that this is making sure that the devices cannot be connected to the internet, we support that. In fact, I believe the Ballot Law Commission, as part of their criteria, is also added to their approval process.
Thank you very much. With that, we'll close the public hearing. Do I have a motion to go into executive session? I have a motion and a second to go into executive session. All those in favor say aye. Does the committee want to exec 1157? Do I have a motion? Have a motion of ought to pass from Senator Ward. I have a second from Senator Birdsall. Discussion. All those in favor of ought to pass say aye. Aye. All those opposed? Do I have a motion for consent? I have a motion second for consent. All those in favor say aye.
Aye.
All those opposed, nay. And I guess I haven't taken one out yet today, so I'll do that. House Bill 1046. House Bill 1046 is dealing with Sullivan County and a change to how their commissioners would be elected. They would be elected by the districts instead of county-wide. We also have House Bill 1397, which, although deals with Rockingham County, had amendments on it in the House that would have expanded that. And I think that any decision that we make ought to probably go on 1397, in my opinion, and that I would accept a motion of interim study or ITL on move interim study.
So just for clarification, Mr. Chair, you're planning on putting 1046 onto the Rockingham County Commission?
If there is the desire of this committee to make a change, then
Okay.
I would want that change to be inclusive of all the counties that have asked us to do something. And 1397 is the one that not only was there what was passed by the House for Rockingham County, there was also an amendment, although soundly defeated by the House, to do more than that. And so I don't, in my opinion, it is better to. And so we have a motion to interim study from Senator Susie. Do I have a second? A second from Senator Birdsall. Further comment? Seeing none, all those in favor of interim study say aye. Aye. Any opposed? Do I have a motion for consent? I have a motion for consent,
Second.
and we have a second. All those in favor say aye.
Aye.
Aye. And Senator Susie, you made the motion, so. Okay, we have a motion to come out of executive session
So moved.
and seconded.
Second.
All those in favor say aye.
Aye.
And we still have a minute, so you can get your files together. Thank you. Tim, you can come on and sit in the chair at least. Oh, my phone just turned to 1:30, so sit down. We'll open the hearing on 12:03 and introduce the prime sponsor. Welcome, Representative.
No, thank you very much, Mr. Chair. So I'm reasonably happy to introduce my bill HB 1203, except I'm actually opposed to the amendment that was put forward by the House Election Law Committee and approved by what I think was a mostly partisan vote on the floor of the House. Because, so that's basically they did. Partisan held pretty much mostly the exact opposite of what I had in mind. They did do, well, although they did in section 2, they do improve the voter registration forms somewhat, which were changed in the bill SB 3 back, I think it was in 2017. And they were famously, like, for example, an explanation in there that was written at a PhD level of reading. And I actually saw some people who, my town of Durham, who were actual PhD students who, well, actually they did manage to understand them, but you could tell even they were kind of like their eyes were crossing and they were looking a little befuddled by it. So anyway, I should probably say my name is Timothy Horgan. I represent Stratford County District 6, which is the towns of Durham and Madbury. It's also the home of University of New Hampshire, and it's not entirely coincidental that my long list of co-sponsors is mostly people who are either affiliated with or live near the campus of the University of New Hampshire, because that's an issue that's a special concern to us, voting rights for everybody, including students. So, and as well, the section 1 in particular is so poorly drafted, I'm not exactly sure what it does. I've reread it several times. I do see it's certainly nothing that we had in mind with the bill, and it seems to be. And I guess I do understand it's related to the ongoing controversy over voting domicile versus residence, and various parties have been trying to create a distinction between a resident and somebody who's domiciled in New Hampshire, and and if that was successful, to lead to like a rather unfortunate situation where you'd have like citizens who are living in New Hampshire who are present or residents but wouldn't be eligible to vote, and that's to my mind extremely undesirable. And actually, so I've got a somewhat convoluted legislative history in my written testimony. I don't know how much of it I need to go into. This is we had bills. I think this is the 4th session where we have bills in it, and actually the amendment doesn't even address one of the issues that my bill and the ones I introduced before it had, which was the question of we have like the question. There's like it's a question of residency, whether we added language back in several years ago that said for the indefinite future, and I'm not sure exactly, which really doesn't change the meaning of the law much, but it was sort of perceived as possibly an attack on voting rights for those who recently moved here, especially college students. Although, as far as I can tell, the amended 1203 basically doesn't even touch that part of it, and I'm not terribly worried about it because if you live, everybody's future is indefinite, so I'm not sure what adding the phrase for the indefinite future to those two particular RSAs changes at all. So what I had in mind originally was just to put the voting law back the way it was before 2017. So it would have undone HB 1264, which was passed actually in 2018. And actually, though, the bill now, and then And also the bill would have undone SB3, which I referred to. So that had those voting forms were highly unpopular, had many problems, and actually are not being used because of the result of litigation in both state and federal court. So we're actually back. They've actually, in fact, we've been using the old forms because there's an injunction against them. So, and SB3 didn't just affect students' right to vote, it affects a lot of types of people, but it's a special concern to me and to my co-sponsors because Durham is a college town. So and actually almost everyone, actually, the vast majority of people who live in college towns think student voting is a good thing for various reasons. But the controversy for student voting isn't about me or my co-sponsors. It's about the right to vote, everyone's right to vote. And the federal and state constitutions both clearly state, as does federal voting law, that U.S. citizens have the right to vote where they live. And so that means if you're over 18, if you're a U.S. citizen, then you have the right to vote in the community where you live. And that includes college students who move to a town to attend college. It doesn't matter why you move there. It doesn't matter how long ago you moved there, whether it was a day ago, 30 days ago, or 50 years ago. And it certainly doesn't matter where your parents or any other family members live or vote. So anyone over 18 is adult, their life is their own, they're a person in their own right. So anyway, so you have the right to vote in the New Hampshire community where you live, even if you moved there very recently, and even if you have family living somewhere else. So I'll close by pointing out Article 11, State Part 1, Part 1st of our state constitution states in part, all elections are to be free, and every inhabitant of the state of 18 years of age and upwards shall have an equal right to vote in any election. Every person shall be considered an inhabitant for the purpose of voting the town, ward, or incorporated place where he has his domicile. And I know the committee's amendment to the bill is trying to do something with the definition of the domicile, but I don't support what they did insofar as I can even comprehend what it is they were trying to do. It was not a very well-written bill, in my opinion. So the original version of the bill protects your right to vote, protects everyone's right to vote, and as amended, the amendment that we have before us fails to do so. So my first recommendation would be to restore HB 1203 to its original form or something close to it, or failing that, to please kill it altogether. So I'm in the strange position of introducing a bill that I'm the prime sponsor of and then asking you to kill it, unless you want to either go back to the original bill or fix the many problems with the amendment that's before you. So that's...
All right, well, then why don't we ask the senators if they have any questions of you?
that'd be fine.
Thank you, Representative.
Oh, thank you.
Next on my list is the Honorable Barbara Griffin.
Thank you, Chairman Gray. Thank you, Senators. I'm here on behalf of the Election Law Committee, who has submitted this bill as amended, ought to pass. And I have brilliantly lost what I was going to say about this bill on my phone. So I am officially winging it right now. As Representative Horgan represented to you, this bill was presented to us as a representation of basically taking what was known as SB3 out of the law and putting the statutes in regards to the provisions SB3 addressed back to the way they were before. The need to do that actually had become apparent in hearings in the Election Law Committee. We heard testimony from people addressing changes to the statute that were the statutory provisions relating to SB3 that were still in the books but had not been rescinded. That happens in many areas of our law where our books don't quite catch up with what the law is or what we're enforcing. So it does create confusion. So certainly Representative Horgan, I think, was on the right track in regards to saying this is something that should be changed. Where the majority of the committee felt it sort of went off the track, so to speak, was the fact that the bill actually did more than just remove the provisions of SB3. It in fact added language like indefinite future, despite what you might have just heard. It added an entirely new provision in regards to a claim of domicile, saying a person's claim of domicile for voting purposes shall not be conclusive of a person's residence for any other legal purpose, which in the opinion of the majority was simply far outside the bounds of what was SB3, and certainly contrary to the Supreme Court advisory opinion and what was HB 1264 in regards to the equivalency of domicile and residence. There were also provisions in this bill that were not related to SB3 in regards to the interstate voter checklist, the cross-check program. There was provisions in regards to that in the original bill on page 20. There were other provisions throughout the bill as presented to the committee that were not related to SB3. So in recognition that SB3 should come out of the books, so to speak, and in recognition that in light of 1264, now codified, there should be other changes. Representative Groen from our committee, I would say, largely worked on the amendment, which was incorporated into the bill, which is before you today. So what 1203 as amended does is it eliminates the qualified voter domicile affidavit, which was the 1203 form, and all of those, you might remember the list of criteria that were in the statute in regards to what would constitute qualification for domicile. So that was cleaned up throughout it. And it also kept somewhat a provision of 1203 in regards to the fact that it has a form to be used 30 days before the election as compared to prior. So during the year, when you go to register at the clerk's office, to the extent anybody does it, the reality is registrations are by far occurring on election day. That's when the majority of them occur. But when you go down during the year, you're supposed to bring your proofs. These are not a barrier. These are the proofs of qualification that you're entitled to vote in the place you're registering. Throughout the year, up until 30 days before the election, those proofs are to be brought. If you don't have those proofs in regards to the domicile, you are asked to go back and get them. When it gets closer to the election, in light of complaints that we've heard about stifling votes and ease of vote, there is the affidavit form can be used then in order to substantiate that proof of domicile. So I apologize for having lost my more detailed notes on this. As I said, Representative Groen was the one who worked on the amendment. It is a lengthy bill, so it will, I understand that it will take some checking of what it does. I understand you have other people signed up to speak on this. And let me just check to see if by any chance I can find my crib sheet, and I cannot. So with that, that is 1203 as amended. Thank you.
Okay, questions from committee members? Senator Perkins Pope.
Thank you, Chairman. Thank you, Representative, for the thorough explanation. So are you anticipating any further changes to this version? Because I did have a question about on page 9, lines 6 and 7. It reads, person, I think these are the qualifications to use the affidavit, a person who attests under penalty that he or she does not possess any qualifying documentation of domicile and will not ever be able to possess any qualifying documents of domicile shall complete the domicile affidavit.
That was put in, thank you for the question. I
Yes,
don't know whether
ma'am.
you were
No,
done
no,
or not.
please
Sorry,
proceed. Yeah,
Senator.
of course.
I'm just so happy I remember this clause and I can speak to it. That was to address the issue of persons who don't have a permanent domicile, the homeless or somebody who might be in a shelter and would not have anything when they come, that they would be given a domicile affidavit, so that we would not be barring anybody from voting if somebody says, hey, I'm never going to have anything. That's why that provision was put in there.
Okay, thank you.
Yes, Senator Susie.
Thank you, Mr. Chairman. Just a follow-up to that question. But it says will not ever. I mean, at some point, they may.
But not probably as to that address that they're claiming at that time.
As to that specific address.
Yeah.
Okay, thank you for that distinction, Representative.
A request. There was an amendment written to Senate Bill 418 that dealt with a lot of these same issues that was never introduced because of the way it was written compared to what happened on the vote before that, so that it wasn't appropriate. Could you and Representative Gruen and whomever else take a look at that amendment and see if some of that could be incorporated into here? Because that would allow you to use other data that's available in public records to do the verification of residency and others. And either Trish or I would be able to get you a copy of that amendment should you choose to look at that and possibly amend your bill.
Thank you, Senator. I'd be happy to.
Any other questions from committee members?
Senator Gray, what bill was that amendment to?
418.
418.
SB 418?
Yes, Senate Bill 418. And it was one that was never presented. It was a floor amendment. I
Oh,
think
yes,
you know
okay.
the one. If not, just I'll get the stuff to you.
Thank you.
Okay, seeing no other questions, thank you very much.
Thank you for your time.
All right, one more representative. Again, from the great city of Nashua, second largest city in the state of New Hampshire.
It is.
Okay.
Can you put on your microphone, please?
Sooner or later, I'll understand that red means go. I think I'm here today in opposition to House Bill 1203 as amended on behalf of the minority of the Election Law Committee. And there's really only two little pieces that I want to talk about, but I'd like to start with the language that was just highlighted by the senator on page 9, lines 5 through 7, and share an anecdote with you that perhaps might understand sometimes the strange little situations we've found ourselves in as city clerks or supervisors of the checklist. Before I retired as city clerk in Nashua, a young couple came into the office and wanted a marriage license. We issued the marriage license, and about a month later, the bride came to our office and wanted to register to vote because she had just gone to DMV asking to get a new driver's license for her new address. She had moved in with her husband. He was renting a condo in Nashua, and that was where they were living. Of course, all the bills and the utilities and the lease were in his name. That's the residence he already had. So she had nothing yet that showed that she was living at that address. DMV told her to go to our office and get registered to vote and then bring the voter registration form back to them to show that she was actually living at that address. I had no problems doing that, certainly, because we had issued the license. I knew the couple's arrangements. He had provided that address on his marriage license application, so we issued the voter registration form. With this language in this bill, I could not have done that. We could not have registered that person to vote because she could not swear that she will not ever be able to possess any qualifying documents of domicile. At some point, some of those bills would have been in her name or in joint name. So I have a problem with that particular language. The other point I would like to raise is that I have concerns about the two-tiered registration system that still exists in House Bill 1203 as amended. When the Supreme Court issued its opinion, it stated that there was no need for a two-tiered registration system now that some of the harsh penalties and requirements and obligations that had been reversed by the courts no longer applied. And if you look at the two forms, and I'll highlight the two differences, why I don't really think you need two forms, one for someone who's registering more than 30 days prior to an election and someone who's doing it within 30 days of an election. On the first form, for for someone who's registering more than 30 days before the election, on page 3, line 18, the form actually says, if registering on election day. And of course, this form can't be used on election day because that's more than 30 days outside of the time period. Then if you look on the form that's to be used within 30 days of election day, page 5, lines 5 through 7, this is language that doesn't appear in the first form, but it appears in this one. I understand that to make the address I have entered above my domicile for voting, I must have an intent to make this the one place from which I participate in democratic self-government and must have acted to carry out that intent. We do register homeless people. We are allowed to under state law and required to under federal law. I would not want to be a homeless person having to swear that I intend to be homeless for the rest of my life, because that's kind of what's being asked here. But in other scenarios or situations, I used to register people in nursing homes, and I have a family member now in assisted living. My mother thinks she's going to go home someday. She's not. And, you know, if she had to sign a form saying that she's going to stay there forever so that she can participate in democratic self-government, she would never swear to do that. She might not understand the language, but if I explained it to her, she wouldn't sign it. But, you know, we know that's her residence. Maybe it's for a year, maybe it's for 3 years, maybe it's 5, maybe it's forever. But someone should not be forced to sign a statement saying that they intend to stay there for an indefinite period of time, when in fact they may have no intentions of ever doing that. So those are the two areas that I object to in House Bill 1203, and I appreciate your consideration for those concerns. Answer any questions if you have any.
Questions from committee members? RSA 654:1 is the paragraph that we look at for domicile. And it does have words in there that says that your domicile is that place more than any other where you intend to, and I can't quote it, so I won't bother going any further. How does that square with the language that's in there, and where do you see the differences that you would want to change those words to what is already in statute in 654:1?
I might suggest you use the words that are in the statute, not add new ones to cause confusion. In this particular case, there's a difference between the phrase more than any other, and on page 9, line 6, the words will not ever. And for consistency's sake, if the committee is satisfied with what's in current law, then my thought would be to use what's in current law, not add new language. It's just going to cause confusion.
Okay, thank you. Any other questions? Thank you, Representatives.
Thank you.
And we've got Mr. C. I'm assuming the Secretary of State wants to go last.
Thank you, Mr. Chairman and members of the committee. My name's Alvin C. I live in Loudon, and I'm here on my own behalf, and I'm generally opposed to this bill, but the main thing that I feel is important here is that any person should have their domicile be for all purposes of their life, and not be, there should be no distinction for voting purposes or any other purpose for their domicile. And that's not to stop anyone from being able to change the domicile whenever they need to. And that's really all I have on this.
All right.
Are there any
Questions from
questions?
committee members? Seeing none, thank you very much. Michael O'Brien. Welcome.
Thank you, Mr. Chair, members of the committee. Michael O'Brien with Party Strategies here representing American Votes. I'm not going to waste a bunch of your time because Representative Bergeron took all of my thunder. And so the problems that he enumerated are basically what we see with the issues. If we can fix the wording in those two places, I think the rest of the bill is fine as stands, but those two parts gave us concern. Happy to take any questions.
Questions?
I just
Senator
asked one.
Susie.
So the language that's stricken from the bill, removing all the Senate Bill 3 language makes sense. And it's the two issues identified by Representative Bergeron.
Correct.
Would you agree with Representative Bergeron's suggestion, at least regarding the first part, that using the existing language in 664-1 might clarify and be more consistent?
Yeah, I think that's a great suggestion. It does make sense to keep it consistent throughout so you don't have, confusion within the statutes as you read them.
All right, any other questions from committee members? Seeing none, thank you very
Thank you
much.
very much.
Secretary of State? Welcome.
Thank you, Mr. Chairman and members of the committee. I'm David Scanlon, Secretary of State, here in support of the amended bill. I think the explanation of what the amended version does has been pretty well described so far, and I just wanted to lend my support to removing the language from Senate Bill 3 that was in the statute that the court found unconstitutional is a good thing.
Okay,
Happy to answer any questions.
questions from committee members? Seeing
Thank
none,
you.
thank you very much. They're going to check the list to see if I've gotten everybody. Okay, seeing no other speakers on the list, is there anyone here that wants to speak? Seeing none, we will close public hearing and give us a minute or two and we'll open the next one. I didn't even know this. All right, you ready? We'll open the public hearing on 14. Welcome, Ms. Barnes.
Thank you, Mr. Chair, members of the committee. I'm Michael Yakubovich from Hookstead, representing Merrimack 24, and 1457 is my bill. And it's intended to keep better track of ballots and ballot boxes after the election, provide more clarity to how they are stored, keep a log of where the boxes are stored in each town, who has access to the boxes, what the location of them are, and when they get destroyed, there'll be an entry in the logbook. And this logbook is accessible to the Secretary of State, so he can come in and verify what's going on. In the recent year, there was an issue in Bedford where ballot boxes and ballots were kept showing up for about a year. So something like this should prevent it, should help us. And this simple bill will bring uniformity to every town throughout the state. So there's a log for all the boxes everywhere that Secretary of State, the officials can refer to and check that they've been stored properly and there are no surprises. That's what it is.
All
Thank you.
right, sir. Is there any questions from any of the committee members? It's the only one that's asked to speak, so if you're going to ask a question, it's probably a good time. Seeing none, thank you very much.
Thank you.
That is the only one who's asked to speak. There are 3 other people on the list. All say they support. Okay, seeing no one else, we'll close public hearing. You want to go into exec and do this one?
I move exec.
We have a motion to go into executive session. Do I have a second? Have a second? All those in favor say aye.
Aye.
Okay, do I have a motion on House Bill 1457?
Move on to pass.
We have a motion of ought to pass,
Second.
and we have a second. Discussion.
Second.
Yep, discussion. No discussion? All those in favor say aye. Aye. Opposed? And we're going to move consent.
Second.
Second. Okay, all those in favor of consent say aye. Aye. All those opposed? And Senator Perkins Polka, you're the only one of us that hadn't taken a bill out yet today. So you are. Do I have a motion to come out of executive session?
Second.
We have a motion and a second to come out of executive session. All those in favor say aye. Aye. And we're back in regular session, and the next bill is 1527. Okay. Trish, you ready? Okay, we'll open the public hearing on House Bill 1527, and welcome back to prime sponsor.
Thank you. Glad to be back. Mr. Chair, members of the committee.
You do need to introduce yourself.
Oh, yes,
again,
of course.
Because it's a different bill.
Correct. It's still me, Michael Yakubovich from Hooksett, representing Merrimack 24. And this bill's got to do with the tapes that come out of the machine. So as amended by the committee in the House, the tapes are to be, a copy of the tapes, the long form of the report tape, are to be sent with the return of the vote form to the Secretary of State by the next morning, so that there's a copy kept in the town and the copy kept at the Secretary of State. So the tape will show everything the machine saw. My initial intent for these tapes was for them to be posted online as copies or scans of the tapes. That's been removed from the bill itself, so it's up to the Secretary of State on what they're going to do with the tapes. My hope is that they will transcribe them into some kind of a spreadsheet that's going to be accessible to the public, so the public can view each machine and just see what the machine did, the error counts, the votes, everything. So this is, yep, this is all the bill is about. Thank you.
Just as a clarification, I don't believe that the bill actually talks about putting them in the spreadsheet. It just says that you will print a copy to send to the secretary, and that you'll print a second copy that'll be retained with the records in the town.
Yes, thank you. That is correct. Before it was amended, I had that inclusion in it, which spoke about a spreadsheet, but right now it does not. Thank you.
Okay. Any additional questions from committee members? Seeing none, thank you very much. We've got Representative Bergeron, you're at the top of the list here.
Thank you, Mr. Chairman, and I apologize. I did not introduce myself, I think, the last time I was up here. Representative Paul Bergeron, Hillsborough.
It was my fault.
No, well, I'll take the blame. Hillsborough 29, thank you. And I'm speaking in support of the bill as amended. The sponsor was correct that there were a lot of additional requirements provided for in the original language of the bill. However, the committee voted for the amendment 20-0, and it was approved by voice vote on the consent calendar. The current practice is for city and town clerks to submit the long report tape from the AccuVote machines to the Secretary of State. It's not in the statutes. It does appear on page 94 of the election procedure manual, where it directs the clerks to submit a duplicate copy. So there's already, by codifying it and putting it into law, this will ensure, we hope, that all city and town clerks will follow that recommended practice. But in addition, we want to make sure that if people wanted to see those tapes locally, the city or town clerk would have a copy on file as well with their copy of the return of votes forms. So we didn't think this requirement was burdensome. We're just expanding a little bit on current practice, and it does get the tapes into the public domain so that the public can have easier access to them if they so wish.
Questions? The long tape, as I understand it, provides a little bit more information, like in the overvotes, undervotes. Could you expand
Correct.
on that?
It's been a few years since I've run those tapes, but yes, there's more detail in them. The short report might give you the final results. When you get into the long report, it's providing a lot of additional information on votes cast. It's required actually for primaries because you can't get all the results you need for a primary election without running the long results tape. So it is more detailed, and that's the one that the Secretary of State recommends be submitted with the return of votes.
Okay, thank you. Oh, Senator Susie has a question now.
Just one additional one. On line 12, obviously, we're referring only to AccuVote because that's the only one currently approved by the Ballot Law Commission.
Yeah.
We would have to amend this law if the Ballot Law Commission were to approve some other device, wouldn't we?
Yes, the amendment specifies long results tape, which is terminology used specifically by the AccuVote machine. If there was a new machine, they might have different terminology for its various reports.
Thank you.
Seeing no other questions, thank you very much.
Thank you.
There are two other people who have signed up in support. Is there anyone else that wants to testify? Seeing none, we'll close the public hearing and we'll have a motion to go into executive session. Do we have a second? All those in favor say aye.
Aye.
Senator Susie, it sounds like I've got a motion coming.
Sure, I can move on to that.
OTP, and a second. Discussion?
1527.
1527. Okay. Seeing no discussion, the motion is ought to pass on House Bill 1527. All those in favor say aye. Aye.
Move consent.
Any opposed? Well, I gotta say opposed.
Okay.
I yell at people.
Thought I heard
Excuse me, I
everyone.
discuss that with people when they don't, so and we have a motion to go on consent.
So moved.
And all those in favor of consent say aye.
Aye.
Aye. Okay.
I'll
And
take it out.
Senator Birdsell will take it out. Okay. And here's my list. Um,
87.
Sure. House Bill 87.
I'll move interim study.
We have a motion on House Bill 87 for interim study. Do I have a second? I'll second it. Okay, this was the electioneering bill. I wasn't convinced by the testimony that there was a need to change the language that we had. I don't know how the rest of you felt about that, so further discussion?
I felt the same way, Mr. Chairman. I think interim study motion is probably a polite motion. You know, I'd be happy to just go along with that. I would have gone along with ITL as well. I think that we've worked really hard in recent years to try to deal with the issue, and I thought we had struck the right balance, so I don't see why this is necessary at this time, but I'll support the interim study.
Further discussion? All those in favor of a motion to interim study on Senate Bill 87, say aye.
Aye.
All those opposed? Do I have a motion for consent? Have a motion for consent? And I'll second it.
Needed a
It's
second.
okay, it's okay. I can do it. Further discussion, no. Everyone in favor, say aye.
Aye.
Opposed? And anybody want to take that one out?
Yeah, I'm not taking
You
this.
made
I'll
the
take it
motion
out.
on the last one, Senator Susie.
I'll switch with you then. You can take this one and I'll take the one.
I'll take this one out since it looks like it wants to be an orphan. All right.
No, nine.
On just a discussion, I don't think that we're ready to vote on 144. But what we did in the Senate bills is we made a change to this. So Senator Susie, I'm going to ask you to look over what we have in this bill to either make it conform with what we did with the Senate or bring forward something that makes it different than what we did in the Senate, because I don't think our position should be different on one bill versus another bill, so.
I'd be happy to do that, Mr. Chairman, and I'll talk to Representative Bergeron
Okay.
doing that.
And 514, ballot rotation. I believe that the Secretary of State still owes us a final version. If he is going to do that, invite the Secretary of State up to the desk if he wants to comment on that.
Mr. Chairman, I was paying attention to what I was reading. and what
Okay.
you were saying, so.
No problem. We'll get you in the chair anyway, so.
Well, you sure did that.
Okay, this was House Bill 514 on the ballot column rotation. I think you've given me a preliminary. I am not opposed to the bill the way it is right now, going from 1% to 2%. But you said that out of 20 hours, that only saves you 2. So I'll let you comment on what you are looking towards doing.
So, Mr. Chairman, I think we can live with whatever way the committee wants to determine how we're going to come up with party column rotation. The bill that is before you, as amended by the House, relaxes it by a percentage point, which certainly helps, but it doesn't take away a great deal of the workload that's involved with doing it that way. The bigger issue in my own mind is that it is a process of determining column rotations that I cannot simply tell you how it works. That we'll put one of our best mathematicians on it, and they'll come up with a process that involves some tweaking because everything doesn't come out perfectly, and that'll be the way it is, just as it was done 10 years ago. Excuse me. But if you ask me to describe how we came up with that formula, I cannot tell you. And so in terms of being transparent and open about how these election processes work, that's problematic. What we did before the formula that we currently use, after the court had ruled that we had to rotate the party columns, was we simply did it by Senate district. And there was a random drawing of which Senate districts would fall into which columns. And then there would be a drawing to determine which party got which column. And then the way that shook out was that, one column would be the Democrat column, one column would be the Republican column, one column would be the other column. It's straightforward. You can explain it. People can see exactly how it happened. And the rotations were done on a fairly even population basis because 24 Senate districts divides by 3 pretty easily. There would be 8 districts that would fall into each column. So I think that's a reasonable alternative. Does it get to the exact, most fair process that you can probably get? No, not as good as the rotations system that we've come up with. It is very difficult to explain, but it is fair and it is random, and it is something that can be easily explained. So I'm happy to go with whatever way the Senate would like to go on that. But I just throw that out there as a way to be more transparent in the process.
The best of my recollection is what I've gotten from you was labeled preliminary. And so if you would firm up those ideas, get it to Trish, she will send it out to the committee, and we'll hold on this one until we get that.
Okay.
All righty. Thank you very much. And it's time for us to come out of executive session for the next bill. We have motion and a second to come out of executive session. All those in favor say aye. Aye. And our next bill is House Bill 1467. You can come up and say it. We won't yell at you for sitting. Okay. All set, Trish? Okay. And we'll welcome the prime sponsor. Welcome, Representative.
Thank you. Thank you, Mr. Chair, members of the committee. I'm Michael Yakubovich from Hooksett, representing Merrimack 24. And here I am presenting 1467, House Bill 1467. This bill will give us a few more data points. So whenever a recount is being conducted, this bill is asking to conduct, to also tally up some other office, the office that's not being questioned by a recount, by the office that's not requested to be recounted. Because when the ballots are pulled out and every ballot is looked at and being analyzed by every which side, we can collect more data by looking at another office that's not part of the original request. So the bill calls for one of the top ballot offices to be recounted on a ballot. And that office will be picked by the Secretary of State, one or two offices actually. So the cost for including an extra office and tallying it up is marginal. And I think the time spent will also be minimal. Because again, the boxes are open, every ballot is being looked at, displayed on the screen, shown to everybody, to all the witnesses. So we might as well collect information for some other office so that we can present this data to the people and analyze it, or the people can. People want to have more data, so that should be available. I believe with showing that some random office, not a random office, but another office that's not being requested, questioned, the recount to be shown to be valid, will provide, will demonstrate to the people that our elections are solid. It'll further ensure that our elections are good, that we're counting every vote the way they're intended to be counted. And if there's a subsequent recount in the state, the Secretary of State will pick a different, yet another top of the ballot office. So we can go through that and verify that office as well. I think that's all I got. That's what the bill is about. Thank you.
Okay, questions from committee members? Senator Ward?
Thank you, Mr. Chair. Thank you for taking my question. How do you see a partial recount, a town, a district? What part of it?
Oh, thank you. I would only look, thank you for the question. I would only request to look at the ballots that are already retrieved for that candidate. So for a state rep, it's just say a single town. So that's what we're going to be looking at for the top level office. Thank you.
Senator Susie.
Follow up, if I may, to the same point, but what if the recount is being done for a congressional candidate? So you would be doing a partial recount of all of the ballots for half the state?
Thank you for the question. So all those ballots will be retrieved and will be in the room for a congressional candidate. So as we are going through congressional candidate, I would recommend that we also pick one of the other offices there, say for a senator or a president, to be tallied up, since every ballot is presented already. So it's an extra column we got to look at. Thank you.
If I may.
Senator Susie.
I have concern about there being, I understand you expressed that it wouldn't be a lot of time, but if we're talking about the primary, given that we have such a late primary and the tight time constraints to prepare ballots, wouldn't that impose an undue burden on the Secretary of State's office if the recount were for one of the primary offices that you identify?
Thank you. That's a valid point. I believe the secretary will speak after me. So yes, let's please hash it out. And I think we're all interested in better data to be able to verify our elections. So thank you.
Thank you, Representative.
There are only 3 of you that have signed up to speak. I'm going to ask this question now so that all of you can comment on it when you testify. But if I do this, and the last recount that I was going to be conducted, which would be 7 to 14 days after the election, causes me to do another recount of a ballot at the top of the ticket, then I'm not going to know the results of that ballot at the top of the ticket until, if I say 14 days after the election, I complete that, it identifies a problem, or I'm going to do a statewide because it's, and then just the logistics of getting that done, getting the ballots there, it's going to push me out at least a week, if not longer. How do I do that?
Thank you for the question. So it's a 2-part question. So the first part, I think, is, do we want to know that there was an issue at the top of the ticket? And I believe everybody will say, yes, we want to know, right? So, and I mean, if we can catch an error and detect it while we're doing this new additional recount, partial recount, we do want to know that there was a problem. How do we deal with that problem? I think that's the second part of the question. Does it push it out too far? And that's a valid concern, of course. So, I would treat it as a 2-part question. And the first one, I would say, yes, I want to know there was an issue. And second, again, I would maybe defer to the Secretary of State on how to resolve it. What do we do? Are we being pushed out too far? So I would want to collect the data. So thank you. I hope that answers part of the question.
I'm going to give myself a follow-up too. The Senate passed a audit bill where we're going to go look at the AccuVote machines, and we're actually going to do an audit of a certain percentage. Doesn't that accomplish the same thing as this bill and do it in a much more timely manner? Or are you not familiar with that bill?
Thank you. Yes, I'm not quite sure what that bill does exactly. If you would.
We'll save that question until one of the 2 other speakers gets up here, and we'll ask it then. Questions, other questions from the committee members? Thank you, Representative.
Thank you.
All right. Let's see.
Thank you, Mr. Chairman and members of the committee. My name's Alvin C. I live in Loudon. I'm here on my own behalf, and I am in favor of this bill. And this, perhaps I'll start with follow up on the question that you had regarding Senate Bill 366. This bill would in no way conflict with that. It may overlap if a bill that was, or a town's ballot who had them go through your high-speed scanner happened to also be involved in a recount, then there would be overlap. But what this bill does is give the general public a better idea of the accuracy of counts for higher offices, which are not usually recounted. And it only uses the ballots that are already sent into Concord for a recount. It doesn't require any additional ballots to be shipped around or anything like that, but it does add a little bit more time for the process of counting because you're counting additional names on ballots. But they're the same ballots that are already unboxed and out on tables and being examined. This method of audit provides a somewhat random sample of towns and cities. Obviously, some districts are less likely to have any candidate call for a recount just because of the demographics of the districts. But it just won't, you can't actually predict what towns or what districts are going to have a recount in until after the election occurs. And in the after the 2020 general election, there were 16 recounts requested that included 55 towns and cities in 7 counties. So that's a fair amount of a sample, but it's also fairly random. Some of the cities and towns were involved in more than one recount. For instance, the town of Lynborough was involved in the executive council recount, a Senate recount, and a state rep recount. So obviously those wouldn't have to be examined a second time or a third time. So there can be overlap. And that pretty much covers my testimony. And it might be that there, on a primary election, if this shows a larger than a 1% discrepancy and the candidate thinks that there should be a recount for one of those higher offices, that may be well worth having, even if it means we have to delay the general election to be able to accomplish that, just because people are very concerned about the ability to correctly count the ballots. And there's a lot of concern about machines counting ballots incorrectly. So,
Just to comment on that, I believe that it might be possible for a state office to delay the general election, but I believe that the federal law requires the date for the representatives, senators, and president, and we would have no ability to do that. And those are the exact offices that you're talking about recounting. Comment?
well, that would, I would think that you could either make an exception so that it requires a bigger trigger or some other event, or not at all for having an additional recount afterwards as based on this. But overall, the concept, I think, gives a lot more confidence to the people that the ballots are being accurately counted.
Additional questions from committee members? Seeing none, thank you very much.
Thank you.
And last on my list, Secretary of State. He's batting cleanup again.
Thank you,
Welcome, Secretary.
Thank you, Mr. Chairman, members of the committee. I'm David Scanlon, Secretary of State, here in support of House Bill 1467. I I do recognize the issues that the committee has raised, and if there was a recount requested of one of the top tier offices that would be subject to the recount, you may want to waive the requirement that another office be counted at that point, because you're actually counting, the office or an office that's a target of what's being proposed here. The second point that I wanted to bring up too was Roman numeral 3 from an administrative perspective, just raises some questions for me. If there's a discrepancy of greater than 1%, the candidate is justified to request a full recount of that race. It doesn't say anything about the process by which that would take place. Would the candidate pay the fee that would be required in that instance? That's a question. I would also suggest that we identify discrepancy that this bill addresses as an unexplained discrepancy, because we can do a recount for state rep race that may have a variation of greater than 1%. But if we take a look at the ballots where the voter did not follow the instructions and mark the oval, but the intent of the voter was otherwise clear, that's a discrepancy that can be explained. And so I think we should be looking at unexplained discrepancies of greater than 1%. And I think if that was the standard in Wyndham, we would have, the candidate, if it was a situation where there was a crease going through one of the ovals in a top tier race that we couldn't explain, like we couldn't explain what was wrong with the count for state rep, that probably would have ended up in, a recount for that office, because that was an unexplained discrepancy until we had the forensic audit that took place and made that determination. But I think if we put unexplained discrepancy, the number of recounts that would potentially occur under this would be quite small.
So I'm gonna ask a question. They can yell at me afterward. So if I have a person who's running for register of probate, and there is a write-in campaign, and election night results comes out that there's 50 votes for somebody and 20 votes for somebody else, out of a county in we'll make it Rockingham County, then I'm going to do a recount of all of the ballots, because those candidates want to know who really won. 99 and 44/100% of the ballots are going to be blank, and I'm also going to count one of the higher offices according to this bill. Is that right?
That would be extreme, I think, and it would be nice to be able to address that. Yeah, no, I see the point.
Questions from any other committee members? Senator Susie.
My question is similar, but I agree with the chairman. This says for each official recount. So my reading of this is that if you have, which is oftentimes the case in a primary, 22 separate requests for recounts, because you have multiple state rep, you could have county offices, you're going to have to do double the amount of time, but it won't be until necessarily the very last recount occurs that someone in that county could then determine they want to recount as a result of what happened. And once again, given that we have a September primary, do you have any concern about your ability to prepare ballots in a timely fashion to comply with UCAVA and to get everything ready for the general election?
Yes, I mean, obviously, if this bill were to pass, even without the scenario that you just described and the chairman described, we would have to ramp up our recount workforce to be able to handle this. And, obviously, we would have to expedite all of the recounts that would be requested so that we could address any time constraints.
Additional questions from committee members? Seeing none.
Thank you.
Thank you, Mr. Secretary. That's the end of my list. There were two other people who are in support, but did not wish to speak. Anyone else change their mind? Representative Griffin.
Thank you, Chairman Gray. Thank you, members of the committee. As I sat here and listened to this, I'm actually a little embarrassed as chair of the committee that sent this to you to say, I think it needs an amendment. And one of them is, I'm not convinced that it amends the proper section of the statute to begin with. I have to admit, I don't always check that the way I should when bills come in front of me, and I think it maybe should be in a different part of 660. I think the underlying intent of the bill is something that had great support in the House, and I would like to see it go forward. And I think that with the permission of the chair, I might have a conversation with the prime sponsor and a couple of other people about whether or not amendment might address some of the issues. Because if the issue is not one that we think we have a problem, but just to have assurances going forward that things are operating correctly, perhaps the solution is to have it be provision for the general election only, not primary elections, and to limit it to candidates who have registered to be on the ballot as compared to write-in candidates, because the qualification is certainly different for that. So those were the points I wanted to bring forward to the committee. Thank you.
Questions from committee members? Just as a comment, if you limited it to like state rep races, have recounts and the offices, I mean, between the executive council, if we had that, and you were doing a recount of a second race, you've already done, a fifth of the state, which seems a little, and, even in the Senate district, a 24th of the state, where, again, I'm just offering that as a comment that I guess personally from the Senate's point of view and what happened in our committee about auditing, I would rather see the time and expense go into auditing more of the AccuVote machines pre-recount than I would a post-recount additional count. But again, that's just my opinion, and we're not in executive session, so I probably should have waited until we got there, but mea culpa.
Well, since you didn't, Chairman Gray, can I comment?
Would I believe? Would you believe?
Thank you for those comments, Chairman, but I would point out that I believe the audit bill is for this upcoming election, after which there's supposed to be a report and further consideration of how to proceed. So I agree that certainly there appears to be a duplication of counting, but I think the audit is addressing really a different issue. And that issue is that while I think a number of us have confidence in our elections and how they're run, the reality is across the country, we are one of only a handful of states that do not have an audit procedure. So I think that's what the bill that is currently in front of my committee from this committee is trying to address. I think what this bill is trying to address is the concern that we saw arise this past election in regards to the accuracy of results in races that might not be the focus of a recount. State rep races, as you referred to, are the most recounted races. There are more of us. The races are closer. And so you're doing lots of recounts. So I can tell you, I heard comments from a lot of people. Well, people know you're watching those rep races. Those aren't the races that people are going to try and tamper with. So I think you can do a couple of things by passing both the bills. Thank you.
Additional questions? Seeing none, thank you very much, Representative. And I asked last time if there was anybody else and got somebody, so we'll do it again. Seeing none, we'll close the public hearing. Just, if we get a motion to go in executive session, I don't know that we're going to act on any of the bills that are on the list, but so that we can discuss them and
Sure, we'll be going to executive session.
we have a motion to go in executive session. We have a second to go into executive session. All those in favor say aye.
Aye.
All those opposed? Okay, I think I was on, did I do, 1009 or not?
No,
Okay, this was the date that a person registers.
I don't,
I think that one, I want to keep it on hold for right now,
yeah,
so that people can go talk to their, this certainly would be data that would be gotten by the various parties to do various lists and would aid them in updating their, but I'm not necessarily thinking that that's something that I need to worry about in my position as a state senator. But
Mr. Chairman, if I could, my concern was that when the Secretary of State testified, their practices before 2002 were different, and we may not actually be capturing accurate information. It's going to vary from city to city and town to town, whether or not it would accurately reflect things that occurred before that. So I just have some hesitancy with moving forward with the bill in its current form.
okay, so we'll leave that one on hold. House Bill 1021, I've got that one on hold also. There certainly was discussion about treating a religious property differently, but if that religious property was the home of someone and they're asking just because they have some kind of religious service there for a short period of time each week, whether or not, and that in there was, I think, where the conflicts come in. Anybody want to comment on that before we go on to the next?
I'm sorry, what was that you said was the conflict that,
That a religious organization that is trying to build a church and a civic center and whatever else should not be treated any different than anyone else that's going in and doing that. Should not be asked to do anything more. The fire laws ought to be the same. I mean, the setbacks ought to be the same and
Right.
those things. But if you have someone who says, okay, I own this property and we're going to use the dining room and the living room, which is combined for church services on Sunday, and I want an exception so that I can put in a parking lot that doesn't meet the setbacks. So that's where my conflicts are in this, is how do you treat people fairly, but don't impinge on their religious freedom, but also, don't impinge on the neighbor who doesn't want, the neighbor having the parking lot that goes right up to the fence.
and I guess my concern, and I agree, I mean, I think having a weekly meeting, a religious meeting in your house on Sundays is probably disruptive on a weekly basis. But my concern is if the reason it's being done is because there's ordinances that are being put in that are making it difficult to build that church or that, that's where I have my concerns.
Yep.
Because they don't have an alternative place to be able to meet unless they put up a tent on the property. I know there's some towns that don't like that either. So, I mean, I get the fact that neighbors are upset on a weekly basis, but is it because they are being forced to use that particular house because they can't get their building permits or build?
All right. Oh, Senator Ward. I was looking down. I apologize.
I would like to know exactly what the special conditions are that they are being required. And we just heard that they have, that they do it, but we don't know what they are. The only thing I can think of is, for example, if a regular house is going on a regular basis have certain number of people all the time, are the trusses strong enough to hold it? But on the other hand, you can have a party in your house and the floor could move a little bit, but you still have more people than you normally would have. So I would like to know exactly what are the conditions that they put upon a church that they do not put on other buildings.
And for that, you may want to have contact with the prime sponsor.
Well, I noticed that supporting the bill is Ian Hewitt, who is an attorney. I can contact him and find out if he knows of any cases as to why this is being brought forward.
And if he does provide input, if you get it to Trish to give out to the committee.
I'll just make a final comment, which is, we did get an email from, I think he was one of the attorneys involved in the Hanover case that I think is prompting this. And my concern just remains also that we make sure municipalities know what they can do in the wake of this law. So he indicated that the language we have in the bill is pursuant to First Amendment case law. So I'm just going to reach out to him to see if he can share a case with us that we should be following, and I will also share that with the committee.
Okay. Moving right along, 1069. I put a hold on 1069 because of Senate Bill 200. I'm told that the House may be using Senate Bill 200 for a different purpose. And so I've asked for an amendment that puts the language from 200 into 1069 because they both dealt with village district and commissioners, etc. One in Hillsborough and one in Merrimack. So when you get that, don't be surprised if they end up not using 200 for something else. Then when it comes back, or if it came back, we would take care of it then. But if the language is the same, it won't be a problem. Next bill is 1081. Myself personally, that if I'm going to do away with something that's enacted in law, I'm not really comfortable in that happening on just a majority vote. That if I know that a lot of the laws that we enact, when a certain party is in, things get voted in, and when a certain party is out, other things get voted in. These elections, that where we would do this kind of thing, if you think back to some of the things that we've had before us in the past, like voting, changing a town from a traditional town meeting to an SB2 town, and then people who show up at the actual meeting that would be able to change it is a very small percentage, but they are people who are on one side or the other. And so it creates conflicts. So I guess, that is someplace that, somebody's got a brilliant idea and wants to bring it back before us. But I'm certainly, for those reasons, not in favor of just a majority. But again, we'll put that one on hold and let people think about it. Cybersecurity issues, we put that on hold for 2 weeks. The 2 weeks is up. But I haven't gotten anything back from Commissioner Goulet. Did you have input on that?
Thank you. Good afternoon, Mr. Chair. Curtis Barry here for Microsoft. Folks from Microsoft had an opportunity, in fact, today to speak with Commissioner Goulet with just some input on what they've seen from other states and the impacts and the federal government. I think the conversation was great both ways. We have no issues. I don't think there's any changes coming forth other than there might have been an amendment initially before the hearing. So from our perspective, we're good to go, and Microsoft supports the bill.
So if you communicate with the commissioner and tell him to send us something, I would appreciate that. Or if you want me to do it, I can do.
I'm happy to do that. Yeah. Yes, sir. Thank you.
All right. Thank you. Lengths of term of office, 1397. We talked about that briefly when we were doing the other one. I believe that the voters in the communities ought to get a say in this. And I've asked NHMA through Margaret and the counties through Ms. Horgan to think about that, come back, whether that means that the towns would have a warrant article on the ballot, and the cities would have a question on their ballot, and the results would go to the county convention, and the county convention would be the one that actually could do it, or some other thing that I can't even think of. With the stuff that was in 1397 right now, it came through with just the one county. Then they expanded it with an amendment, but all the votes on those two things were division votes, so you can't go in by county and look and see who voted for it, who voted against it. In the past, when we've had the whole county delegation coming in and asking us for something, that generally we've honored the request of the county delegation. But I have no way to know. And I think to get out of this at some point, if there were a way to let the people choose. How many years ago when we had the request to make the governor 4 years? That was a constitutional amendment, as I remember. And I believe that was soundly defeated, but that's just my memory. So,
Mr. Chair, what are you saying? That you want the state rep or the towns to put in warrant articles to show support for this and then bring it to the county delegation? But didn't the county delegation vote on it in the House?
well, they would have voted on it in the House, but if the people in Sullivan County didn't want it and the people in Coas County did want it,
But isn't it up, I would think it would be up to the different counties if they want to change it, to go ahead and move to do it.
and that's exactly what I'm saying. But again, I offered that as a solution, not the solution. And I've asked Kate, who represents the county people, and NHMA, who would represent the towns in that conversation, to get together and to have a discussion and bring us the results. But
Okay.
that's just my opinion. If this group wants to take some action on the bill, other than that, then I can always, be the odd person out if, or whatever.
No, let them do their work and see what they come up with. Yeah, I'd rather hear from them, and I think since we put the other bill dealing solely with Sullivan County into interim study, I want to make sure we're prepared to deal with that in some fashion in this bill. So be happy to hold.
Okay, it is held. 1567. The one thing that I had in my notes on 1567 is I circled that old box, that old word that, the shall thing in there. I guess I'm looking for input from all of you on what do you think about that? What we need to do or not do? And for the shall piece of it, it could say that the Attorney General is responsible, and that takes shall and may both out there, and it says that he's responsible.
The existing law provides that somebody who knowingly fails to perform their duties or knowingly performs in such a way as to hinder the objects is guilty of a misdemeanor. So it already gives the Attorney General that authority. I guess the part, and I think NHMA objected to this as well. So you have an individual who acts inappropriately, but yet you're going to make the taxpayers of a town or a city have to pay a fine for the actions of that individual. Shouldn't we go after the individual? I mean, I don't understand the imposition of the penalties on the political subdivision itself.
I think that's part of the issue that when it's brought to the towns, I can speak from the Wyndham aspect. When it's brought to the town, and I brought it to the selectmen's attention that the Attorney General had found that there were a number of things that they had violated. They did nothing. The selectmen did absolutely nothing. So I think there's frustration when you, yes, I agree that the individual who violated the law should be brought up on charges, but as of yet, nothing has happened in either Wyndham or frankly Bedford. Although I think they're still investigating Bedford.
So in other parts of the statutes, we do have penalties for other election officials.
For the official.
Right. And this would go towards the town. So I guess are you suggesting that, that the words go in there that if the town hasn't taken appropriate action or something, or how would you, it may not just be the individual. It may be that the town shares some of the guilt.
Because my concern with the bill is that we don't want those who volunteer to feel that a simple mistake will incur liability. I'm sure that they do their jobs very carefully. But I agree with Senator Susie's concern that it's common for someone acting in their official capacity to have a certain amount of, basically leeway and immunity in doing that responsibly. So if a knowing violation is already covered under law, then we're talking about, unintentional mistakes creating consequences.
I think the problem starts on line 9, where at the end it says shall cause the county, city, town, school district, or other political subdivision where it occurred to be subject to a civil penalty. I understand if there were others involved within the town or there was something they could do, but this doesn't say that. This just says that a public officer who negligently performs their duty potentially creates a fine liability for an entire community, where I just want to put the blame and the fine on those that actually caused the problem, as opposed to spreading it out to the community.
Well, one way to do that would be to take out of not less than and put in not more than, and leave that part in. Therefore, if the city, took appropriate action, even though something like that happened, it could be that there would be no fine. Is that a way to get to win-win? Well, I'll tell you what we'll do. Since everybody's being quiet, we're going to put this one on hold. Let people think about it.
I'm going to talk to Attorney
Yeah.
Lehman.
And unless someone had something, and I don't see anything, our business being complete, we are adjourned.